Now let's take a look at the first slide, Part 2, Citizenship, Articles 5 to 11. Articles 5 to 11 covers the citizenship rules under the Constitution of India. So Part 2 has 7 articles, 5, 6, 7, 8, 9, 10, 11. We will study each article one by one. If you look at the articles, Article 5, 6, 7, 8, 9, 10, 11. These are the 7 articles under Part 2 of the Indian Constitution. Article 5 talks about what it takes to be a citizen of India at the commencement of the Constitution. Now, a very important point that you need to understand is that Article 5 talks about citizenship at the commencement of the Indian Constitution, which is to say, the rules don't apply to our present era. These rules only apply to how a person can acquire citizenship of India at the time the Constitution came into force. So Article 5, Article 6, Article 7, and Article 8, and Article 9, okay, these articles only apply to citizenship at the time of the commencement of the Indian Constitution. Now, you look at Article 11. Article 11, Parliament to regulate the right of citizenship by law. Right? It gives Parliament the power to regulate the right of citizenship by law, which means using Article 11, they can pass a law regarding citizenship rights. Okay, so they have made several amendments. The first act that they created using the power under Article 11 is Citizenship Amendment Act of 1955, which is the act that we use even today. Okay, and the Act of Citizenship 1955 gets updated every 20 to 30 years. So every amendment is an addition to Citizenship Amendment Act, Citizenship Act 1955. Okay, so Act 1955 is the act wherein all the citizenship rules are mentioned, and we will study about that. So Article 5 to 11, we will study one by one. But before we study, let us first understand the concept of citizenship. Now, in layman terms, what is citizenship? It simply means the state of being a citizen of a particular country, right? But you should not use this term in your examination. In political terms, citizenship means legal relationship between an individual and the state. Okay? If the state legally recognizes you as a member of its country, it means you are a citizen of that country. And as a citizen of that country, you enjoy full political, civil, and constitutional rights. Now look to your right. We have political rights. As a citizen of India, you enjoy political rights, which means you have the right to vote, you have the right to contest elections, you have the right to hold public offices, which is to say, you have the right to give NPSA examination and get a job. That is your political right. And civil rights, you have the right to equality, you have the freedom of speech and expression, and constitutional protection. In case anything happens, the fundamental rights under Part 3 of the Indian Constitution will protect you. Okay? And the fourth point is very important. We follow the single citizenship rule. There are countries in the world that provide dual citizenship. Okay? You have almost all the European countries, France, Europe, Spain, Italy, England, Portugal. All these countries provide dual citizenship. You could be a citizen of France as well as a citizen of England. But India does not offer dual citizenship. If you are a citizenship of another country, you are not a citizenship of India. Okay? It's explicitly mentioned in the Indian Constitution that India only allows single citizenship. So, a very important point to note. India does not recognize dual citizenship. India follows single and uniform citizenship for all. Now, are we clear with the concept of citizenship? Now let's move to the first, Article 5, citizenship at commencement. Now, the condition of India at the time of the commencement of the Indian Constitution was such that some people were migrating from Pakistan, some people were coming in and out of Pakistan, in and out of India, and so forth. Or there were questions and doubts about some princely states not wanting to join India, and there were some states like Nagaland which demanded independence, and various other states. Okay, so at the time, to be a citizen of India, it wasn't difficult. It was very easy. So if a person became an Indian citizen, you could become an Indian citizen on 26th January if you resided in India and if you fulfill at least one of the following conditions. So our grandparents, let's take the example of our grandparents, on 26th January 1950, they were likely alive. They were likely here in Nagaland, 26th January 1950. And if they resided here in Nagaland, it means they automatically became a citizen of India. Okay? Or if they were born in India. Or if either of their parents were born in undivided India, which means Indian subcontinent, Pakistan, Bangladesh, India. Hutu tinda majude janam huishe gulibe. Abnila ama baba. Either of your parents. Or if you had resided in India for more than 5 years before 26 January 1950, which is to say 1945, 26 January, 1950, 26 January, at least 5 years before the constitution came into force. Pas sal tak kulibi India de thagili do, you became an Indian citizen. Now, any one of the following conditions caused it, which means even if you were not born in India, even if none of your parents were born in undivided India, even if you did not reside in India for more than 5 years before 26 January 1950, as long as you resided in India at the time of the commencement of the constitution, you became an Indian citizen. Or let's say you were not domiciled in India, you were not born in India, neither of your parents were born in undivided India, but you resided in India for 5 years, right before the commencement of the Indian Constitution, then you became an Indian citizen. So the trick is, you need to fulfill just one of the following 4 conditions. Okay, so that was the eligibility criteria to be a citizen of India at the time of the commencement of the Indian Constitution. So Article 5 simply states these conditions in order to be a citizen of India. So that was the original rule, original law for citizenship in India. It was very lenient, it was very forgiving, it was very merciful, but now it has become much more stricter. Okay, we will learn about that later on as we study the different amendments. Now let's move to Article 6. Like I mentioned earlier, the political situation of India was unstable at the time. Okay, so they also had to add in a clause for people who migrated from Pakistan to India. Some people, they changed their minds and they came back to India. What happens to them is mentioned in Article 6. Right? How can they become an Indian citizen? Okay, a person who migrated from Pakistan to India is eligible for citizenship if himself or herself or tala ama baba nulibi tala grandparents was born in undivided India. Okay, undivided India. So which means Pakistan ba apni aishiguli the automatic citizenship pawale thaka utula rule hisab te do, because technically everyone, 99.9% of the people would have been born either in Pakistan, Bangladesh or India, right? Undivided India. So that's number 1, okay? Number 1, eligibility criteria. The paragraph on the right is point 1. If you yourself or your parent or your grandparent was born in undivided India. And second condition, before 19 July 1948, if you were continuously residing in India before 19 July 1948, now just imagine, it could be a little bit confusing, okay? But when did the Indian Constitution come into force? 26 January 1950. And It was at that exact time, 26 January 1950, that they wrote about this rule, saying that Puila, Tuisal Agere, 19 July 1948, Utulaga Agebai, India de Pui Jashibiledo, automatic citizenship power. That's the only statement. Okay, that's the only statement. Automatically eligible if that person was continuously residing in India before 19 July 1948. But after 19 July 1948, registration compulsory ase. Why did they give this rule, specific rule? Why did they decide 19 July 1948? Because before 19 July 1948, it was open to everybody to come to India, to go from India. But on 19 July 1948, they introduced a system called permit system. Okay, just like the ILP, inner line permit, they also had the permit system, and then they started checking because there was an unlimited influx of people coming into India, right? They were not checking, and there were security concerns, and which is why they introduced the permit system on 19 July 1948, which means before the permit system, if they came to India, if they already came to India, they will be a citizen of India. But after 19 July 1948, they need to follow the rules of the permit system. They did not mention permit system here, but practically permit system was used after 19 July 1948. Okay? And another condition, condition number 4, 6 months residence required before application for registration, which is just a supplementary article to, supplementary condition to the third condition. After 19 July 1948, you have to register, and before registering, you need to be in India for at least 6 months. Okay, you need to be in India for at least 6 months. You can't just come from Pakistan all the way to India and directly apply for registration. You need to reside in India for at least 6 months. That was the condition in Article 6. Now we move on to Article 7, migration to Pakistan, which means Indians who migrated to Pakistan. Article 7 is just a declaration that Amni Pakistan jaisu biledo India manu nohe. You lose your citizenship, you are no longer a citizen of India. That's the rule. General rule. Migrated to Pakistan after 1st March 1947, not an Indian citizen. So it's an open declaration that anyone who left India for Pakistan will not be considered an Indian citizen. Okay? But the exception is Article 6, right? Article 6, the one that we discussed just a few minutes ago. Not an Indian citizen, but there's a but, Article 6 will apply if they came back to India again. Maaf ko dibo. So Article 6 and 7 is all about the Pakistanis, okay? Pakistanis and the Indians can like issue as it. Now next, we move on to Article 8. Article 8 is for persons of Indian origin abroad, which means a person with whose origin is India, but he is not in India. He's somewhere outside of India, but his origin is India. That is what we mean by persons of Indian origin. Okay? And they're abroad, which means they're not in India. So, eligibility criteria for those people, again, this rule is only for people at the time of the commencement of the Indian Constitution, okay? And at that time, there were people, PIO, persons of Indian origin. Let's use the term PIO. I hope you won't get confused. So these PIO, in order for them to be eligible to be a citizen of India, right? First of all, a person qualifies as an PIO if they were born in undivided India, either of their parent or grandparent were born in undivided India, right? And so their requirement to be a citizen of India is they must register as Indian citizen before the Indian embassy or consulate in every country of residence. India at present has Indian embassy in almost every country, okay? And there they send Indian Foreign Services officers, right? So the Indian embassy of that particular country where the PIO, the person of Indian origin, is residing, he needs to register himself as an Indian citizen at that particular embassy of the country where he or she is residing. That's the only condition. Okay, very simple. In order for the person to be a citizen, he needs to register himself as an Indian citizen at the embassy of his of the country that he or she is residing. Indian embassy. Okay. So important note: registration is mandatory. Registration is mandatory for those PIOs. Citizenship is not automatic for PIOs living abroad. Okay. The Indian diplomatic mission in that country is the competent authority for registration. The Indian diplomatic mission, which means the Indian embassy. We move on to the next. Article 9. Again, Article 9 talks about foreign citizenship, which means apni foreign law citizenship luisi gule do India citizenship no hoite goina declare kura ase Indian constitution ba. Simple, very simple. There's no hidden message, nothing complicated. Article 9 simply declares that if you acquire foreign citizenship, automatically you are not a citizen of India. Okay? Key rule: voluntarily acquiring the citizenship of a foreign country results in automatic loss of Indian citizenship. Okay? Such a person cannot claim citizenship under Article 5. We talked about Article 5, the general rule. Article 6, the Pakistanis, right? Or Article 8 of the Indian Constitution, the persons of Indian origin. None of these three categories, Article 5, the general people, Article 6, the Pakistanis who migrated to India, or Article 8, persons of Indian origin, the PIOs. These three, none of these three can claim citizenship if they already have citizenship of another country. Okay, that's the rule. Article 9 is very simple. It talks about foreign citizenship. If you have foreign citizenship, you cannot acquire, you are not an Indian citizen, you cannot be an Indian citizen. Why? The last point, India does not permit dual citizenship. Let's move on to Articles 10 and 11. Okay, I'll merge it together, but it's very easy to understand. Article 10 says that whatever we have discussed, Article 5, Article 6, Article 8, whatever we have discussed, all these three categories of people, once they get citizenship, Article 10 is about continuance, which means you will continue to be a citizen of India. Okay, after you get it, after you acquire the citizenship, you will continue to be a citizen of India, unless otherwise stated by the Indian Parliament. Okay, that's the only statement given in Article 10. It only talks about the continuation, letting people know that it's safe, right? You are safe, you will continue to be an Indian citizen, unless the Parliament makes another law again in the future. But as of now, you will continue to be an Indian citizen. And Article 11, I mentioned earlier, Article 11 gives the Parliament, Indian Parliament, the right to make laws for citizenship. Okay? And using that Article 11, various acts were introduced, amendments were introduced, which we will discuss about once we are done with these two articles. Article 10, continuance of citizenship, I explained it. Article 11, it gives Parliament the power to make laws for citizenship. And the scope of Article 11, okay, the Parliament may legislate on, may make laws on, the bits and bits, the details of citizenship, acquisition by birth, right? If you're born in India, by descent, or if descent meaning if you descended, if your parents are Indian, okay, by registration, if you register, right? You're not an Indian, but you register. Or naturalization is another process, okay? For those who are not related to India in any way, be it his parents or be it yourself, but you wish to be a citizen of India. It could be the wife of an Indian who is not an Indian, and he resided in India for a certain number of years. By process of naturalization, you become an Indian citizen. We will discuss on that later. So, Article 11 gives the Parliament to legislate on all these subjects, okay, which come under the purview of Indian citizenship. Article 11 simply gives the Parliament the power to make laws for citizenship. Now, are we clear on Article 10 and Article 11? Quick revision. on Article 5, from Article 5 to from Article 11, from Article 5 to 11. Article 5, we talked about citizenship at the commencement of the Indian Constitution for the general public, right? For the general public, we talked about the 4 conditions. And Article 6 is about people who came from Pakistan, who migrated from Pakistan to India, right? Article 6 gave various conditions for people who migrated from Pakistan to India, if they came before 19 July 1948, if they came after 19 July 1948. And Article 7, we talked about people who went to India, went to Pakistan from India. Right? They left India and they migrated to Pakistan, not as citizen, just a declaration made, okay? In Article 7. Article 8 is for people of Indian origin living outside of India. For them, registration is required, right? So 4 very important points in Part 2 of the Indian Constitution, okay? Now in Citizenship Act 1955, this Citizenship Act 1955 continues to be the main source of rules and regulations regarding citizenship for the entire nation up to this day. Okay, whatever acts are introduced after Citizenship Act 1955 are simply amendments to this act. Okay, we will learn about the different amendments. For example, Citizenship Amendment Act 2019 was a very controversial act, right? That only excluded one religion, Muslims, from acquiring citizenship. We will discuss about that later. But all the amendments that will come after this is simply making changes to Citizenship Act 1955. Okay, so always remember that this is the core act of Indian citizenship, and any amendments that came after this are simply amendments that supplemented Citizenship Act 1955. So right now, at the present, and Citizenship Act 1955 first a lot of changes have been made because a lot of amendments have been introduced, okay? But what I am going to teach you today is the present rules and regulations mentioned in Citizenship Act 1955, which is the only thing that you need to understand. If NPSC asks you certain questions, they are going to ask you about the rules that stand today, at the present. So Citizenship Act 1955, the background and framework. How did they create it? Article 11 empowers the Parliament to regulate citizenship. Point number 2, the Parliament enacted the Citizenship 1955, right? The Act governs, number 1, acquisition of citizenship, means how to acquire citizenship, is mentioned in Citizenship Act 1955. And next point, termination of citizenship, how your citizenship can be taken away, or how you can terminate your citizenship, and how you can register, and how you can be an Indian citizen by process of naturalization. And lastly, overseas citizenship of India, which we will also learn about later. So next, now we have covered Citizenship Act 1955, and inside Citizenship Act 1955 we have acquisition of citizenship, termination of citizenship, right? So let's begin with acquisition of citizenship, okay? There are 5 different ways of acquiring Indian citizenship. There are 5 modes of acquiring Indian citizenship. Number 1, by birth, which means if you're born in India, right? And number 2, by descent, means if you descended from your parents who are Indian. Number 3, by registration, so which are available to PIOs and spouses of Indian citizens. For example, if you married a Mexican man, he can apply for Indian citizenship, and he needs to go through the due process of registration to become a citizen of India. And by naturalization, which means if you are in no way related to India, but you wish to be an Indian citizen by process of naturalization. Okay, we will discuss on that as well. And by incorporation of territory. Citizens of territories becoming part of India. For example, if tomorrow we go and we conquer Bangladesh right now, all the people of Bangladesh will automatically become citizens of India by this rule, by incorporation, by rule of incorporation. So these are the 5 ways in which we can acquire Indian citizenship. Okay. So the first one, there are 5 ways of acquiring Indian citizenship. The first one is citizenship by birth, right? It's mentioned in Section 3 of the Citizenship Act 1955. Your eligibility depends strictly on the date of your birth in India. So if you were born before July 1, 1987, which I'm sure none of us come under that category. All of us are born after 1st July 1987, but mokan la ama baba na bisibak to they were born before 1st July 1987. So you are a citizen if you are born in India before 1st July 1987, regardless of your parents' nationality, which means people born before 1987, so mano ama baba Indian citizen hole na lage, eko condition na lage, automatic citizenship. Okay? If you were born in India before 1st July 1987, automatic citizenship. If you were born between 1987 to 2nd December 2004, at least ama baba ekjun do Indian citizen howo lage. I come under that category. And any of you born before 2004? Yeah, 1, 2, 3, 4, 5. Yeah, 5 of you were born before 2004, which means Moando, we Mon 1, 2, 3, 4, 5, 6. 5 of us though, Amma Nule Baba Indian citizen howo lage. Okay. And after 2004, anyone born after 2004? Yeah, 2004. Okay. 2004. You are an Indian citizen only if both parents are Indian citizens, okay? Or to be Indian citizen no ekta do Mia no lage. Mia no lage. Mia, we call them Mia, right? Illegal Bangladeshi immigrants or illegal migrant. Okay. The reason why they use the term migrant and not immigrant is it's a little bit derogatory, right? A migrant is a person who moves from one place to another, very simple. But an immigrant is a person who moves from one place to another with the intention of settling in that place permanently. So which is why we call the Bangladeshis immigrants, right? Here, the Bangladeshis who reside here in Nagaland. So both your parents to be Indian citizen, or if Indian citizen actually no live, at least illegal immigrant no like it. That's the rule today. Okay. Now it evolved over time. And we will learn about that in the following slides. Now, citizenship by descent. By descent means mala ama baba, you descended down, right, from your forebears. So, what is the rule for this citizenship by descent? Before then, December 1992, if you were born before 1992, okay, you are a citizen of India if apni janam hua dam de 1992 la age de janam hua dam de baba the Indian citizen thagile. Okay, by descent, which means why it's almost the same as citizenship by birth, right? But here in this case, you don't have to be born in India. What if you were born in China? Amar baba honeymoon trip de jaise China de phasi jaise ek saal aro apni China de janam hoise. But apni China de thagile bhi 1992 10 December la age de janam hoise gule do apni la baba Indian citizen ase gule do automatically apni bhi Indian citizen hoi ja ase inika ko ase age la do born in India, right? Yade do by descent. Okay, you don't have to be born in India, anywhere in the world, but the condition is that apni 1992 10 December la age de ase gule do baba Indian citizen hobo lage. Between 10 December to 2nd December 2004 asegule do either okay 92 la agi do khali baba lai luide believe 92 to 2004 do ama aro papa actual Indian citizen huile. Why? There was this one citizenship amendment act, okay, we will learn about that later. Who the amendment act pra change kodisido. Earlier citizenship to khali mota baba ekla Indian citizen huile loi dakse, but people protested against it, saying it's discriminatory against women. Okay, khali baba Indian asu bole do bacha Indian bole. To aji gali do amma noile bi baba Indian huisi bole do bacha bi Indian ho paro. Okay, so if you marry an American and you wish to settle in Nagaland, you have every right to acquire Indian citizenship for both your husband as well as your children. Okay, always remember that, right? And from 3rd December 2004 onwards, not automatic, okay, which means the two of you born after 2004, not automatic. You cannot become an Indian citizen automatically. The condition is that your birth, okay, must be registered at the Indian consulate within 1 year of birth, along with a declaration that the child does not hold a foreign passport. So, what does it say? It's only for children born outside India, okay? If you were born in India, if you were born in India, but what if apni America de janam hoise? Ama baba thaigelibi, ama baba Indian citizen thaigelibi, ama hoilibi, baba hoilibi, noile tuijun hoilibi, Indian citizen hoilibi, utubabi najule. You have to register at the Indian embassy within 1 year. Janam hoa bishide. Okay, if you were born outside India. So that's the condition. But if you were born in Dimapur, Kohima, Longling, Mokshung, but born outside India, within 1 year, you have to register your birth. Okay, that's about it for citizenship by descent. Now next we move on to citizenship by registration. This is usually for PIOs or people with close family ties, like your spouse. Let's say you got married to an American and the American wishes to be an Indian citizen. This is the method that he will have to use to be registered as an Indian citizen. Or if you're a person if you have Indian origin but you're living abroad, then you can use this option. Common eligible categories. You can become an Indian citizen if you are a PIO. You can become an Indian citizen if you have been a resident in India for 7 years. 7 years tak India de thagi do. Even if you are an Indian origin living abroad, as long as you stayed in India for 7 years, you are eligible for Indian citizenship. Very easy, right? Or if a person married to an Indian citizen, okay, who has been alternately resident in India for 7 years. Again, if you got married and you were residing in India for 7 years, which means for a girl, if you got married to an American, the American needs to be in India for 7 years, and then he can become an Indian citizen by process of registration. Okay, and for a guy, if you married an American lady, the lady needs to be in India for 7 years before he can register as an Indian citizen. Okay, or children of parents who are citizens of India, minor children of parents who are citizens of India, but these minors not born in India, outside India, right? They can register, which is related to the earlier that we've talked about, born outside India. Even if your parents are citizens of India, minor children born outside of India, they need to register, okay? Now next, by naturalization. This option is only for people who have no relation to India, no close family ties, no parents who are Indians, nothing. Completely new. Whom can you think of? An Indian citizen, a person who become an Indian citizen by process of naturalization. There's one very popular figure, okay, if you guys can remember. Someone who is not an Indian but became an Indian citizen by process of naturalization. Mother Teresa, okay, Mother Teresa. She became she's an Albanese, right? She became an Indian citizen by process of naturalization. Now, what's the condition? Number one, not an illegal immigrant, not an illegal migrant. You have to reside in India for 11 years out of the past 14 years. Now is the year 2026. The past 14 years means 2013 to 2026, right? Between those years, at least 11 years, to 14 years, 11 years, at least India lagi. Okay? That's the rule in order for you to be naturalized as an Indian citizen. And you need to possess adequate knowledge of at least one of the 22 languages mentioned in 8th schedule of the Indian Constitution. One of the 22 languages, Marathi, Konkani, Malayalam, any of the 22 languages mentioned in the Indian Constitution. Okay? Now, Citizenship Act 2019 exception. 11 years out of 14, right? 11 years out of 14. But Citizenship Amendment Act 2019 reduced the period of 11 years to 5 years. Okay? For persecuted minorities who entered from Pakistan, Bangladesh, and Afghanistan on or before 31st December 2014. So 5 years to 11 years. 11 years to 5 years. We will discuss more on Citizenship Amendment Act 2019 later on. Okay? Now we have come to citizenship by incorporation of territory. No explanation needed, right? No explanation needed. But let me just give you some interesting facts. Datra and Nagar Haveli, it was owned by Portugal. Okay, it was owned by Portugal. So they, before 1961, it was part of Portugal. After the agreement signed between India and Portugal, in 1961, Datra and Nagar Haveli became part of India, and automatically the residents of Datra and Nagar Haveli became Indian citizens. Okay, and Goa, Daman, and Diu as well. The residents were full Portuguese nationals before 1961, and after India incorporated these territories, the residents of Goa, Daman, and Diu became Indian citizens automatically. Okay. Now Puducherry is another very unique case. The residents were French. The residents were French subjects, and so the French government officially ceded the territory of Puducherry to India in 1962. Okay, and so after they ceded the territory to India, after they gave the territory of Puducherry Lobi India, 1962 there, the Indian government, they gave the inhabitants of Puducherry the option to either be an Indian citizen or a French citizen. Okay, so few of them chose French nationality, which is why the official language of Puducherry even today is French. Okay, not English, not Hindi, it's French. They speak French really, really well in Puducherry, and roughly around 6,000 of them retained their French citizenship at the time, 1962, and now the population is more than 10,000. Okay, more than 10,000 French people. So where did they vote? They vote for the French government. Okay, every time there's an election in France, they set up polling booth in Puducherry for the people of Puducherry to vote. Very interesting, right? So yeah, the people of Puducherry, more than 10,000 of them, they are French nationals, French citizens. So which means they're not Indian citizens. They are not Indian citizens. They vote for the French government, okay, and then they are governed by French laws. The civil, criminal laws, both French laws, July. So please remember that. And Sikkim as well. Before 1975, okay, they had a king. Sikkim, India was a protectorate of Sikkim until 1975, which means India was kind of like a big brother. But Sikkim wasn't officially considered part of India. So the people of Sikkim, they were not considered Indian national. But after 1975, there were some problems, and the people revolted against the king, and the monarch was Chokyal. Okay, They call it the Chokyang monarch. And then in 75, the uprising and everything. So the king had to step down, the monarch had to step down, and then the people decided that they wanted to be a part of India. And so India came and incorporated the territory of Sikkim as part of India in 1975. So automatically the people of Sikkim, they became Indian citizens. Okay, so that's the entire process of incorporation of territory, which leads to automatic citizenship. But the case of Puducherry is very unique because it was a very peaceful transition, and even the French requested that India respect the nationality of the people living there, and so India agreed to it. But in the case of Tatra and Nagar Haveli and Goa and Daman and Diu, it was a little bit complicated. Portugal can't accept Koranai. Okay, so the tussle, right, which is what a lot complicated Thakish. So they were not exactly, there were no options given to the people of Tatra and Nagar Haveli or Goa and Daman and Diu whether they should become a Portuguese citizen or Indian citizen. That is the direct automatically eventually some on the Indian Huijishi. But the transfer of ownership of Puducherry to India was done so peacefully by the French national government that even India respected the residents of Puducherry and told them, if you wish to retain your French nationality, you can. And some people did. Okay. Now the problem that arises out of such things, because some people of Tatra and Nagar Haveli still has retained their Portuguese citizenship. Okay. Now what's the benefit of being a Portuguese? What's the benefit of being a French? You're not going to go there, right? What's the benefit, Kushiguledo? Euro visa, we call it Euro visa. Okay, if you have that visa, there's only one single card for the entire European nation, which means if you acquire the visa in France, you can travel to Italy, you can travel to Spain, Switzerland, Denmark, Norway, England, everywhere. So they take advantage of that, and then they travel to London seeking jobs, job opportunities, and so forth. Okay, so they're exploiting the rights given to them. So it will be another problem, as we will discuss on that later. Now, how can you lose Indian citizenship? We already talked about citizenship through different means, 5 modes of acquiring citizenship, right? We talked about birth, descent, and so forth. Now, how can you lose Indian citizenship? Number 1, renunciation. Okay, you have to voluntarily surrender. I renounce my citizenship. I do not wish to be an Indian. So that's renunciation. Self-declaration. Termination. Termination, again, after you acquire the citizenship of another country, your Indian citizenship will be terminated. Okay? And deprivation. Deprivation means if you commit a crime, this and that, right, and so forth, it is ordered by the central government under specified conditions. Fraud, disloyalty, etc. You will be deprived of your Indian citizenship. And note that I've mentioned, renunciation and termination are voluntary, right? You do it yourself. Renunciation, you voluntarily announce yourself. And termination, you acquire a citizenship of another country. So these are voluntary, whereas deprivation is compulsory by government order. I will discuss more on deprivation here. Deprivation, grounds for deprivation, okay? Fraud, false representation or concealment, disloyal to the Constitution of India, traded with an enemy during war, imprisoned for more than 2 years, 2 years or more, within 5 years of acquiring citizenship. So if Mother Teresa had been in jail for more than 2 years, her citizenship would have been revoked. Okay, so that's the rule after you acquire citizenship. And resided continuously outside India for 7 years or more. So if you acquire Indian citizenship, 7 years nahe. At least 7 years la lamba na jawa lagi. Utu machide kitewa time to time I take lagi. I take lagi. Noile do amni la Indian citizenship to kati di. Okay? So very important. It applies only to citizenship acquired by registration or naturalization. Mondo by birth, asudo or descent. Right? Part of India, we've always been a part of India, but people who become Indian citizens through registration, they were not in India. People of Indian origin, or children with Indian parents but born outside India, or naturalization means people who with no relation to India, like Mother Teresa, but they continued to be in India and wanted to be a part of India. And by process of naturalization, they became Indians. So this deprivation of citizenship only applies to those people who acquired citizenship by registration or naturalization. Mohando, by birth or descent, Mohan's citizenship, কি কারণে রিমুভ করবো মন তো জেল যাব that's it life jail will be খাবো 10 years will be 20 years will be না there's no question of citizenship but bar manu will for security reasons okay security reasons now we have the Citizenship Amendment Act 1986 now we are done with Citizenship Act 1955 okay now whatever is mentioned in 1986 we have already discussed that in 1955. Like I said, every amendment after 1955 added to 1955 Act. So what we're going to discuss here has already been added in 1955 Act, okay? So, but then we will have a look at it, 1986, what changes were made to 1955 Act. Citizenship Act 1955 is the core act of Indian citizenship. And any amendments after only make changes to Citizenship Act 1955. Now, Citizenship Act 1986. Okay, the background was that during the 1980s, there were large-scale migrations. Okay, of people coming in from Bangladesh, and then they had to make the rules very, very strict. Demand for stricter citizenship provisions. Now, the key changes made by 1986, number one, it ended unrestricted citizenship by birth. Okay, unrestricted citizenship by birth. Now, what did we learn? You take a look at your right. End of unrestricted use soli. Okay, we call it use soli, right of the soil. Before 1986 Act, India generally followed use soli, granting citizenship to almost anyone born within its territory, right? That was the general rule initially, okay? But now we discuss about either of the parents should be Indian. So they added this condition. The 1986 added this condition, okay? Excuse me for a second. So, 1986 Amendment Act was mainly enacted to ensure security for India. It added one condition. Back then, if you were born within the territory of India, you could become an Indian citizen. Okay, the Citizenship Act 1955 stated that if you were born within the territory of India, you could become an Indian citizen, which means your parents, your grandparents, they don't need to be an Indian citizen. Automatically Indian citizen as long as you are in within the territory of India if you were born. But the 1986 Act added that either of your parents should be Indian. We studied Citizenship Act 1955. This is 1955. This is 1955, right? This is 1955. This is 1955. This is 1955. Registration. This is 1955 by descent. This is 1955. Right. So here we discuss about either of your parents should be Indian citizen. So 1986 by 8 crucially. Janam yadi janam mushi Indian citizen ho ina thakado Bangladesh can take tak thamadam aisha. Aigina do India de settle ho jashi. The Indian government be had to keep at to grow like tan janam hoigina Indian citizen ho na bro amanuli baba do Indian citizen ho like utu check kuro lage na iniga utu introduce kushe. Now, is that clear? 1986. This is the only point that you need to understand. Use solely do use sanguinis. Utu tuita, okay? Solely do sanguinis. 1986 amendment. If they were to ask you question, right? That made India switch from right of soil to right of blood. It's 1986 amendment. And then it added the condition that at least one parent must be an Indian citizen. These 2 points, remember Grole 1986 amendment law, kafi ase for your examination. Okay? For your examination, utu tuita points, yat ase gule, don't study unnecessarily everything. Utu tuita points, that's good enough. Now we go to 1992. Before 1992, citizenship by descent. Descent means descendant, right? Ama baba, ama baba, ama baba. We talked about ama baba. Before 92, kali baba la lui lagi. Citizenship by descent was available only through the father. And this was seen as discriminatory against women. So the amendment brought gender equality in citizenship by descent. Which means 1992 ekbra anishe. Either. We discussed in Citizenship Act 1955, right? Either of the parent. Utu 1992 bra shuru ishide. But if you had looked at the Indian Constitution before 1992, it would have only mentioned baba. But only after 1992, amaro baba, amaro baba, ama baba. Itiado, either of the parent. So before 92, only if father was an Indian citizen. But after 92, either parent was an Indian citizen. Okay, so that was a major step towards gender equality. So if we talk about gender equality, if they ask you a man's question on gender equality, this is a very impressive point to mention. 1992 amendment. Okay. Now 2003 amendment. We have the 1986 amendment. Amendment means changes. Okay, changes to the Citizenship Act 1955. So 1986 amendment, 1992 amendment, right? 1986 amendment added one condition that either parent should be Indian. 1992, right? Before 1992, only father. Okay, was the condition for citizenship through descent, but they added father and mother. And now we come to 2003. It was only in the year 2003 that the term illegal migrant was defined. Okay, the term illegal migrant was defined. A foreigner who enters India, please read the definition of illegal migrant. A foreigner who enters India without valid travel documents or overstays beyond the permitted period. So even if you're an American, right, if you have a visa for 60 days, and you stay beyond your period, you are an illegal migrant. Okay, by law, you are an illegal migrant. So key provisions in the Citizenship Amendment Act 2003 introduced the term illegal migrant. Okay, is that easy? Yes. It created legal framework for National Register of Citizens. So NRC, National Register of Citizens, it's a process of documentation. Okay, that recognizes Indian citizens and also filters out the illegal immigrants. So NRC, okay, the NRC registration process. So the NRC was only, actually it should have been conducted for the entire country, but as of now, it's only been conducted in Assam. Okay, it's only been conducted in Assam in the 21st century. Back then, before the 1950s, we had one National Register of Citizens, but it's not too relevant. But in modern India that we know today, NRC was conducted only in Assam, because Assam was the state most affected by IBI, illegal Bangladeshi immigrants. So they had to conduct NRC some years back. So NRC, Assam is the only state that conducted NRC. Okay, in 21st century. That's also another fact that you can note. So it made citizenship by birth more restrictive, and it introduced overseas citizenship of India. So overseas citizenship of India, OCI. What do you understand about overseas citizenship of India? They are not Indian citizens, okay? They are not Indian citizens. They may be PIO, right? Or someone with close family ties, but they receive this card so that when they come to India, they can enjoy certain rights like a citizen of India. Like I mentioned in the beginning, we do not have dual citizenship. So these people, they have citizenship of other countries, but maybe their parents, their sisters are Indian, so they want to continue coming to India. So if you have an OCI card, right, you don't need to go to the police station always, you don't need to go and register and so forth. Certain benefits are provided for OCI, okay? Now, they introduced OCI, NRC, defined illegal migrant. These 3 points are very important for Citizenship Amendment Act 2003. Shall we move to next? Now, Citizenship Amendment Acts 2005 and 15. Not very important, just some small minor details. In 2005 Act, it expanded OCI eligibility, overseas citizen of India. It expanded their eligibility, it made it more lenient, and it also simplified registration processes, right? Very easy to understand. And Amendment Act 2015, Citizenship Amendment Act 2015 merged persons of Indian origin. There were different schemes for PIOs and OCI, okay? Persons of Indian origin, so non-PIOs and PIOs can come under OCI scheme, right? Overseas citizens of India. But not all OCIs are PIO, right? You don't have to be a PIO to get the OCI. OCI could be someone who is not a PIO, but maybe someone like whose husband is Indian, right? She doesn't have Indian descendants. She wasn't born, nothing, no relation, but she could still have OCI. But PIO means a person with Indian origin. Okay, so they merged both these two schemes into one, OCI, overseas citizens of India. Even the PIOs can register for OCI, and non-PIOs can register for OCI. They made it simpler. Okay, so which of the following amendments, citizenship amendments, merge PIO and OCI? The answer is 2015 amendment. Okay, that's the only important fact about Amendment Act 2015 that you need to memorize. The rest, not too necessary. For your mains answer writing, you can maybe note down a few points. Lifelong multiple entry visa, which means you do not have to apply for visa. It's lifelong visa, okay? Exemption from police registration, right? And simplified documentation and so forth. You can mention those points as well. Now, a proper definition of OCI, overseas citizenship of India. OCI was introduced by the Amendment Act of 2003. I mentioned earlier, right? It aims to strengthen India's relationship with the overseas Indian diaspora. Okay. Despite its name, OCI is not dual citizenship. OCI card holders remain foreign citizens but enjoy several privileges in India. They remain foreign citizens. Very important point to note. Okay, so are we clear about OCI? Not Indian citizens, right? It was done to strengthen India's relationship. Important, OCI is not dual citizenship. Okay, now eligibility for OCI. There are certain conditions. एक पढे Indian थाकिसे. Now the condition number 1. एक पढे Indian citizen थाकिसे. On or after 26 January 1950, and he was newly Indian थाका गुली भी. On 26 January 1950 day, eligible to India whole थाका. ना इन्हें एक condition भी आसे. नहीं ता Indian थाका ने उतो time दे गुली भी. Try गुले तो पारो थाका. उतो भी OCI हो पड़े दे. Or belong to a territory that later became part of India. Puducherry, for example, with the French nationals, the French citizens in Puducherry can have the OCI card as well. Okay, is a child, grandchild or great grandchild of such a person. Aru to point 1 2 3 laga grandchildren tak pawo the benefit OCI apply gorle. Aru is a minor child of an Indian citizen. Indian citizen ekta, for example, you go to America, you marry an American man, and you become and your child is an American citizen. But apni la amma baba yadias do. So apni la bacha bhi American citizen huli bhi OCI card apply kuru paro. If tala amma do Indian thakishi kule do. Na? So these are the conditions, okay? Or is the foreign spouse of an Indian citizen? Again, foreign spouse. Spouse means husband or wife. Na? To motaro maiki Chinese hubi, Korean hubi, kiki huli bhi India manulot marry kurishi gule do OCI card hold kuru paro. So that family kan lote visa korle aram de lifelong visa, police lote chawale na lage and all that na. So that's the eligibility for OCI. Okay? Who is not eligible for OCI? Tadi bi shita Pakistan ki koi dishi. Is or has ever been a citizen of Pakistan? OCI nai, or a citizen of Bangladesh. Okay. Karazem shit. Is or has ever been a citizen of Pakistan, is or has ever been a citizen of Bangladesh. Now, if that's the case, then you cannot obtain OCI. Or Baba takpi, grandparents takpi, great grandparents takpi, ek pardo Pakistan or Bangladesh takishe. Right? To that extent, okay. It feels a little funny, but like it's a direct consequence of our security measure, security issues. Right? It falls under any category specifically excluded by the government of India. Okay, so not OCI is available, only the eligible foreign nationals of Indian origin. Okay, so there needs to be a certain catalyst that connects you to India. Then you can receive OCI. Now the benefits of OCI: lifelong multiple visa entry. Okay, no FRRO registration regardless of duration of stay, which means foreign nationals on regular visas, foreign nationals on regular visas often have to register with the FRRO, which means Foreign Regional Registration Office. Okay, but now they no longer need to register in FRRO. Okay, and parity with NRIs in economic, financial, and educational matters. So OCI holders, they receive treatment similar to non-resident Indians in many areas. So NRIs means non-resident Indians, means Indians who are actually Indian citizens but do not reside in India. They have a lot of benefits, right? They get admission to educational institutions. Okay, they can even study in Nagaland, OCIs, right? And they can open bank accounts, right, like NRIs, and they can have access to financial and economic opportunities like invest in stock market, mutual funds, and so forth. Okay, so that an NRI enjoys, but they do not receive all the benefits of NRI, because what is the one benefit that the NRI has that OCI doesn't have? Right to vote, because OCI is not a citizen of India. So there's a difference. But they enjoy a lot of benefits that an NRI enjoys. Freedom to work, study, and reside in India indefinitely. They can reside for as long as possible, for as long as they want. So if we apply for tourist visa to go to London, the visa is limited, right? There's a limit of 3 months, 6 months, let's say. But if you have the OCI card, you can reside in India indefinitely. And you also have the permission to purchase residential and commercial property. Okay? If you're not an OCI, if you're a foreign national coming to India through different forms of visa, other than OCI, you cannot own properties. It is only through the OCI card that you can own property, residential and commercial. Now, there are certain restrictions on OCI holders. Like I mentioned, OCI holders cannot vote in elections, they cannot contest elections, they cannot become members of parliament or state legislature, they cannot hold constitutional offices, they cannot hold public offices reserved for Indian citizens, they cannot purchase, now I talked about commercial, private, right? Residential or private and commercial property, but not agriculture or plantation, okay? Not agricultural or plantation land. So these are some restrictions on OCI holders. They might ask you in the examination. And rights reserved exclusively for citizens, which the OCI cannot have. Article 15, 16, 19, 29, and 30. These are the rights reserved only for Indian citizens. Okay? No discrimination, equal opportunity in public employment, the sixth freedom. Article 29 and 30, cultural and educational rights. 29 being protection of language, script, and cultural minorities. Article 30 being right of minorities to administer educational institutions. Now, other rights, right to vote, right to contest elections, right to hold constitutional offices, which I've mentioned earlier. OCI doesn't have the right. Okay? Now, strongest proofs of citizenship. Now, this is very important. The strongest proofs of citizenship, meaning how can you prove that you are a citizen of India? There will be a citizenship order or citizenship certificate. Citizenship certificate is you acquire a citizenship certificate right when you're registering or by process of naturalization. Us, we don't have citizenship certificate. By default, we're Indians. But people who were not Indians, they have to acquire citizenship certificate. So that's the strongest proof of citizenship, not Aadhaar card, not PAN card, nothing. Okay, citizenship certificate, the strongest proof. And citizenship order, meaning when a territory joins India, example Goa, Puducherry, Sikkim, the government issued an order that by incorporation of territory of Sikkim, the people of the Sikkim region are now citizens of India. They made a declaration, okay? That's the citizenship order, which is also one of the strongest proofs of citizenship alongside citizenship certificate. Now, documents and proofs of citizenship. Please take a look at it. Aadhaar card is not a proof of citizenship, okay? No matter what, Aadhaar card is not a proof of citizenship. PAN card, no. Driving license, no. Ration card, jao lole ja, no. Okay, cannot use your ration card and say I'm a citizen of India. Birth certificate, the only citizenship proof that we have, right? If anyone were to ask you, prove that you're an Indian citizen, you'll likely take out your birth certificate or Aadhaar card, okay? But honestly, it doesn't work. It shouldn't work. But Indian passport is a very strong proof of citizenship. I have an Indian passport and I had to go through this rigorous process of going to the office in Chumakitima and then going for police verification, right, and all that. So they verify everything about you, whether you're a citizen of India. I have to acquire residential certificate and so forth. So yes, passport is a very strong evidence. Okay, it's not officially proof of citizenship, but it has a very strong evidence. Voter ID card too. Voter ID card too, because your voter ID epic card is authorized, signed, sealed, approved by your village council, your community, the deputy commissioner, and everything so forth, right? So it also is a very strong evidence of your citizenship. And lastly, citizenship certificate, direct proof of citizenship. That's the only certificate, citizenship certificate or citizenship order. Utu tita as a director. Baki do, no. So there's not exactly one one particular document or one particular identity card that proves that you're an Indian citizen. Okay, for us, life goes on. Life goes on, right? We don't need to prove. And when the time comes to prove, when the time comes to prove our citizenship, consular signature lui DDV. Life goes on. Okay, in Nagaland, it's easy as it. So we are nearing the end of our presentation. Now these are the high yield exam facts based on the presentation that we had today. These are the high yield exam facts, all from Article 5 all the way till Article 11. Just some important points that I felt was needed to share with you guys. Okay. Article 5 to 11 deals with citizenship. Always remember that. India follows single citizenship. Always remember that. OCI is not dual citizenship. Always remember that. OCIs, they're not Indian citizens. Okay? It's not dual citizenship. NRC framework originates from the 2003 amendment. They've asked us in the previous year's preliminary examination, and they will likely ask again in the coming years. NRC framework, because NRC, the talk has been going on recently. Okay, NRC framework, very important framework, and it's something so important at the moment right now to deal with those immigrants. NRC framework originates from the 2003 amendment, very important. And next, Article 11. Like I said, 5, 6, 7, 8, 9, 10, 11, but it is Article 11 that empowers the Parliament to regulate citizenship. And using the power vested in the hands of the Parliament by the Indian Constitution, the Indian Parliament used Article 11 to create the Citizenship Act 1955 and all the other amendments that came after it. Okay, 1986, 92, 2003, 2005, 15, 2019. Okay, and Citizenship Amendment Act 2019 provides a pathway, not automatic citizenship. Okay, we talked about people who came from, except the Muslims, right? The rest of the religion who came to India on or before December 2019 automatically can become an Indian citizen by process of registration. So Citizenship Amendment Act 2019. That is why it was controversial. Okay, they allowed they allowed the rest of the religion except they allowed even the Christians, except the Muslims. So that is why the complication arose. Citizenship by birth became stricter after 1986 and 2003 amendments. Okay, 1986 added that either of his parents. Back then, if you were born in the territory of India, you become an Indian citizen. But 1986 added if either of your parents were Indian. And 2003 added what? If either of your parents were Indian, but the other one who's not an Indian should not be an illegal migrant. That's what the 2003 amendment added, right? And together, they made the citizenship by birth become stricter. Okay. So thank you very much. If you have any questions, please feel free. And for Citizenship Amendment Act 2019, I will be giving you notes. So you will learn in detail about the 2019 Amendment Act in detail. Okay, it's very lengthy. So I've just given you a gist of it. You will learn more about it in my notes. And if you have any doubt regarding any amendments, 1986, 1992, 2003, 2005, 15, and 19, please let me know. If you have any questions, feel free.